Welcome to Hull on Estates, a series of podcasts for the Canadian legal community dealing with issues and insights surrounding estate planning in Canada. Hosted by the lawyers of Hull and Hull, the podcast will touch on some key considerations when planning estates and wills. Now, here are today's hosts.
Hi, I'm Nick Esterbauer.
And I'm Darien Murray.
Welcome to Hull on Estates. You are listening to episode number 660. Today, we're going to be discussing accounting obligations and circumstances in which courts may decline to exercise their discretion to compel a passing of accounts. But before we get into that, how's everything going, Darien? It's nice to be podcasting with you again.
Yeah, it's great to be together again. Everything's good, just avoiding that nasty weather that's soon to be coming our way.
Yes, yeah, good sign of February and hopefully our last snowstorm of the season, but we'll see how that goes. And of course, it gives us some extra time to be keeping up to date with recent case law. So I guess without delay, why don't we head into a discussion of this case?
For sure. So in this case, this is Reinboldt and Cameron, and the applicant brought a motion for direction seeking a formal accounting from the respondent for the time that he acted as their mother's attorney for property. So he acted for about a year from March 2017 to May 2018. And the applicant in this case was the estate trustee and sole beneficiary. So the applicant believed that there were some issues with the transactions and that she hadn't received all of the financial disclosure and she had only received inadequate responses from the respondent when she had asked those questions. There was also some previous unrelated litigation within the family that had resulted in the respondent owning some property with the deceased as a mortgagee on that property. So the applicant thought that there were some mortgage payments that had been missed and were owing on the mortgage as well.
Right, and just backing up, Darien, so this is litigation there was litigation in the past, but this piece of litigation was commenced after death.
Yes, so this was brought after their mother had passed away. So the main issue that we in this podcast will be discussing is whether the respondent should have to formally pass his accounts as the attorney for property of the deceased. So like I said, the applicant said that the respondent had provided an inadequate accounting and that there were unexplained issues with the transactions in their mother's bank accounts. She said that a formal passing of accounts was necessary so that everything was laid out in a clear, succinct format. However, the respondent said that he had provided large quantities of documentation previously to the applicant, such that he had already informally passed his accounts. He had provided a summary chart listing all of the mortgage payments he had made, showing that he had in fact overpaid the mortgage. He also provided statements showing the amount that was the assets that were in the mother's estate, detailed transaction statements for the deceased's accounts, and profit and loss statements summarizing the deceased's income and expenses.
Right, and let's just pause there for a second, just for our listeners who may not be totally familiar with the process of applying to pass accounts. So Darien, you mentioned an informal passing of accounts. So that's something that can happen outside of the court process, where someone voluntarily makes disclosure to someone who might have concerns about the way things were administered. Whereas, well, I guess there are two different things that can happen with a formal passing of accounts. Someone can voluntarily apply to pass accounts if they're looking for a release from beneficiaries and those beneficiaries are unwilling to release them even after they've tried to address some of the concerns and provided some of the information. Or you can go to court and ask the court for an order compelling that person to apply to pass accounts. So that goes the same way as it does if someone voluntarily passes accounts, except here you've got an order. Usually it sets out the timing. Usually it sets out the period for which the person must pass accounts. And with any passing of accounts, really, it's an onerous process. You need to have the accounts prepared in court format. It's not something that someone without counsel can normally do on their own. It can be quite expensive and it can become protracted litigation. We see passings of accounts where there are objections raised, replies to those objections, examinations even, if we can't resolve the objections at mediation. And in rare circumstances, we see a trial. So, I mean, often it does make sense to take that step of informally accounting and seeing if the issues can be resolved that way.
Yeah, so it's really better for both sides to informally pass their accounts. It saves both of them all that time and money, which in this case, I believe is what the respondent had been trying to do. He was trying to give all of the what he thought was the necessary disclosure to the applicant, so that she had all of those questions answered and saw that he had sufficiently taken care of his mother's accounts and that he had in fact been making those mortgage payments. So the judge then looked to the associate justice looked to the record in front of her, and the one issue that they did address was the issue of standing. And now that's a podcast all on its own, so we're not going to get into that one here. But the associate justice did say that the applicant in this case was a person who appeared to have a financial interest in the estate, so they were able to bring this motion for directions for the respondent to pass their accounts formally. So a passing of attorney accounts is dealt with under section 42(1) of the Substitute Decisions Act, and provides that the court may, on application, order that all or a specified part of the accounts of an attorney or guardian of property be passed. So the Court of Appeal in Zelm, and that's spelled DZELME, said that it was at the court's discretion to order the passing of accounts, and that they should consider two factors when exercising their discretion under section 42(1). So they said that they needed to look at the extent of the attorney's involvement in the grantor's financial affairs, and second, whether the applicant had raised a significant concern in respect of the management of the grantor's affairs to actually warrant an accounting. So if there's allegations of misfeasance or wrongdoing that are ill-defined, or there isn't enough evidence in the record, the court may dismiss the application requiring the attorney to pass their accounts. This is exactly what happened in Lewis and Lewis. The Court of Appeal upheld the application judge's decision to dismiss the application because they found that there wasn't enough evidence in the record that actually supported any misfeasance or wrongdoing. So in this case, the associate justice looked at first the extent of the attorney's involvement in the grantor's financial affairs. They said that it was only about a year, so a very short amount of time, that the power of attorney was involved in the deceased's financial affairs. And they also found that the respondent gave uncontroverted evidence that he acted solely based on the deceased's instructions with her expressed consent, and at no point prior to death did she actually lose capacity. And then second, the associate justice found that there was no significant concern in the management of the grantor's affairs to warrant the accounting. So the applicant's affidavit only made vague allegations of an inadequate accounting, didn't list any particulars. She claimed that the respondent hadn't paid some of the mortgage payments, but didn't specify which mortgage payments hadn't been paid or give any evidence of that. And on the contrary, the respondent had filed a large affidavit with many exhibits, which we discussed earlier in this podcast, balance sheets, detailed transaction statements. He had disclosed hundreds of pages of documents previously to the applicant, like we said, in an informal accounting. So the associate justice found that the applicant failed to raise significant concern of the respondent's management of the deceased affairs to warrant a passing of accounts, and that they didn't specify any issues or concerns with the accounting. The associate justice also did make a comment that the applicant's desire to have a formal passing of accounts so that everything was together in an easy, succinct, and digestible format wasn't a reason for the courts to exercise their discretion under section 42(1) to order a formal passing of accounts.
That's awesome, Darien. Thanks for that summary. So I think this is an issue we're seeing on more and more of our files, where we've got situations where someone's seeking to compel a passing of accounts. There's been disclosure, and we have to consider, and the judges carefully consider, has there been enough that's happened here already? Is there enough disclosure? Are there answers to the questions that have been raised? And is it a good use of the court's resources, really, to let this passing of accounts take place and to be tied up with the next steps in that? And it's interesting to see that the court is becoming, it seems, more reluctant to order a passing of accounts where the information needed has already been presented, even if it may not be in the format you would see in a formal passing of accounts. And I know we've talked a bit about the exercise of discretion here. So under section 42 of the SDA, the court has discretion to order passing of accounts. So if it doesn't think that's going to accomplish much more than has already happened through the exchange of productions and questions and answers informally, that's something we may not see happen. And as you mentioned as well, we do have a standing issue sometimes in these attorneyship passing of accounts, especially during lifetime, where we need to seek leave of the court. That's a whole other issue. We're not going to get into that today. Any other comments, Darien?
I think this case just serves as a good reminder that it's essential for an attorney for property to be keeping record of everything that they do while they're acting in that capacity. They should be keeping those transaction records, having everything kind of prepared to provide to anyone that does request that disclosure, so that in the hopes that they can provide just a simple informal accounting and kind of head off this massive undertaking of a formal passing of accounts.
Exactly. Yeah, that's a really great point. I mean, we often see people who are named in powers of attorney and they don't necessarily know about their accounting obligations, but actually keeping all those records, keeping them organized and being able to answer questions goes a long way in avoiding the formal process, where that's something you may actually want to avoid, and all the time and costs involved in that. Well, I think that concludes our podcast, Darien. Until next time, we want to thank you for listening. I'm Nick Esterbauer.
And I'm Darien Murray.
Should you have any questions, please send us an email at info@hullandhull.com or contact us through the contact page of our website. Thanks again.
This has been Hull on Estates with the lawyers of Hull and Hull. The podcast you have been listening to has been provided as an information service. It is a summary of current legal issues in estates and estate planning. It is not legal advice, and you are reminded to always talk with a legal professional regarding your specific circumstances. To listen to other podcasts or to leave a question or comment, please visit our website at hullandhull.com. Our theme music is Upper Structure by DJ A Kid and is courtesy of the PodSafe Music Network.